I'm going to discuss many different sources that are giving proper context to the Hobby Lobby case. And I'm going to begin with one that could be construed as biased, but I'm using it to start with because it's a starting point for my perspective and what led me to find the relevant sources that I'm going to provide next. And to point out that the liberal bias can often be a reality bias and a fact-based bias because there will be links to relevant, pertinent, and authoritative sources within their stories. So first I'm starting with Scott Lemieux, his article stating that Hobby Lobby is not legally required to compensate its employees with health insurance at all, and that what is erroneously described as a mandate simply means that if corporations choose to take advantage of the tax benefits for compensating employees in health insurance rather than wages, then that insurance has to meet the minimum coverage standards. But as is often the case with specious religious freedom arguments, the corporation wants it both ways, to get the tax benefits without providing the full benefits to employees. And if the corporation wanted to argue that they have no practical choice but to offer coverage, then according to the logic of their own argument, the religion of the managers is not being burdened because they're not paying for the contraception or making the decision to include it in the insurance plans if they're claiming they have no practical choice. So the relevance of this for my argument is that I had to go looking to validate these claims he's making, that Hobby Lobby is not legally required to compensate its employees, and that the mandate only means that corporations are getting tax benefits, and if they are, then the insurance they offer has to meet the minimum coverage standards. And that led me to find that his claims are supported, and I'm going to provide those sources and put the links in the description. These are government sources. So it does turn out that what is being construed as a penalty by the right-wingers is actually what the employer would have to pay to the government in return for government having to pay for that employer's employees not being able to afford their own coverage. And so what I'm going to show is the tax law that states that individuals showing the IRS that they had to pay out of pocket for services will be considered by the IRS and be given, in many cases, a tax credit for that because it will show that they didn't have the income to pay for their own insurance, or that they did so out of pocket. And so the employer, so that the IRS having to reimburse or credit the taxpayer has to be offset from somewhere, and that comes from the employer, which makes perfect sense, because if the employer isn't offering health care and their employee has to pay, then their employee is going to end up getting a tax credit for that. And the government having to pay for that employee's health care has to come from somewhere, and it's coming from the employer for not offering health care in the first place. So it's not a penalty, it's a reimbursement to the government for what the government has had to come out of their pocket for when the employee had to come out of their pocket for money that they don't have. And the only places I was able to find it being regarded as a penalty with any kind of authority whatsoever would be accountants that are posting their opinions online, and they look very formal and authoritative in their language, but nowhere in the language of the government's explanation of the Affordable Care Act described this as a penalty. It's described as something functioning through the IRS between the employer and the employee. So it does boil down to, if the employer wants to give people health coverage, then their health coverage has to be of a certain quality that the government deems appropriate. And if they don't agree with that, then they are free to not provide that person or any of their employees with health care. They can do that. So on to the next. The first source is the Henry J. Kaiser Family Foundation. They are a nonpartisan, nonprofit entity that disseminates healthcare information to policymakers, employers, and the general public. And this is their August 2013 article titled Health Reform: Implications for Women's Access to Coverage and Care. Abortion. The ACA outlines specific provisions regarding coverage for abortions. Under current law, the Federal Hyde Amendment limits the use of federal funds for abortion only to cases when the pregnancy is a result of rape or incest or is a threat to the woman's life. Abortion coverage is specifically banned from being required as part of the essential benefits package offered by plans in exchanges, and all of the exchanges must offer consumers the choice of at least one plan that does not provide abortion coverage. That's on page 9. A very recent article published by the IRS, or update published by the IRS, says that on February 10th, 2014, the IRS and Treasury issued final regulations on the employer shared responsibility provisions under Section 4980H of the Internal Revenue Code. The following questions and answers provide helpful information about the guidance. I'm going to start with the basics of the employer shared responsibility provisions, and in the next I'll show liability for the employer shared responsibility payment. First of all, it says, what are the employer shared responsibility provisions? The employer may be subject to an employer shared responsibility payment if at least one of its full-time employees receives a premium tax credit for purchasing individual coverage on one of the new affordable insurance exchanges, also called a health insurance marketplace. No terminology in there calling it a penalty. It's a shared responsibility payment because, as I said, if the employee pays out of pocket when their wages don't pay them enough to do so, the IRS will give them a tax credit, and that tax credit must be paid for, and it's not going to be paid for by anyone. It shouldn't be paid for by anyone other than the employer, because they're not offering either any coverage at all or coverage that doesn't cover what the worker needs. When do the employer shared responsibility provisions go into effect? They generally are not effective until January 1st, 2015. And no employer shared responsibility payments will be assessed for 2014. So anything that the Hobby Lobby is claiming they're paying now is an outright lie. They are not paying anything. And if they were paying something, it would have to be for 2013, which we know none of this applied to. So the point is moot. Liability for the employer shared responsibility payment. Under what circumstances will an employer owe an employer shared responsibility payment? So this is not a penalty. This is an employer shared responsibility payment, sharing the responsibility of the employee's healthcare needs with the government, because the government had to give a credit to the person that paid out of pocket. For 2015 and after, an applicable large employer will be liable for an employer shared responsible payment only if, and this is going to talk about safe harbors, and there are also delays, so it could easily be pushed to 2016 that these things aren't paid until, so keep that in mind. The employer does only if the employer doesn't offer health coverage or offers coverage to fewer than 95% of its full-time employees and the dependents of those employees, and at least one of those full-time employees receives a premium tax credit to help pay for coverage on a marketplace. And we'll get into the definitions of premium tax credit and other terminology. Or B, the employer offers health coverage to all or at least 95% of its full-time employees, but at least one full-time employee receives a premium tax credit to help pay for coverage on a marketplace, which may occur because the employer did not offer coverage to that employee, or because the coverage the employer offered that employee was either unaffordable to the employee or did not provide minimum value. How does an employer know whether the coverage it offers is affordable? So here we go into the safe harbors. They can use the Form W-2 wages. The employer can look at that and decide that it's affordable by that. Or they can use the rate of pay safe harbor, or they can use the federal poverty line safe harbor. I'm not going to get into those specifics, but just illustrates the three ways that employers are given safe harbor clearly, where they can say that what they're offering is affordable, and that can help prevent the employer shared responsibility payment. So all of these claims that corporations are being crushed under government are ridiculous, because corporations are very good at finding loopholes and are very well aware that these safe harbors exist. Make no mistake about that. Next is the U.S. Department of Labor technical release in February of 2012 titled Frequently Asked Questions from Employers Regarding Automatic Enrollment and Employer Shared Responsibility and Waiting Period. And what the Department of Labor says backs up what the IRS says about employer shared responsibility. The employer could be subject to an assessable payment if any full-time employee is certified to receive an applicable premium tax credit or cost-sharing reduction payment. Generally, this may occur where either one, the employer does not offer to its full-time employees and their dependents the opportunity to enroll in minimum essential coverage under an eligible employer-sponsored plan, or two, the employer offers its full-time employees and their dependents the opportunity to enroll in minimal essential coverage under an eligible employer-sponsored plan that either is unaffordable relative to an employee's household income or does not provide minimum value. And I did notice, I don't know if I'm going to discuss it, that one of the determiners of whether it's unaffordable is 9.5% of the employee's income. In any case, this is only proving that there's consistency between the IRS and the U.S. Department of Labor's description of the employer shared responsibility. And assessable payment is not a penalty, and it's a tax credit it's given to the employee that is absorbed by the employer. Next is the Cornell University Law School's Legal Information Institute publication on the U.S. Code, and notice that when reputable sources are found, they lead to more specific links to the actual law, and they all use the same proper terminology. So it's titled Shared Responsibility for Employers Regarding Health Coverage. Large employers not offering health care coverage. I'm only going to talk about them because it illustrates that Hobby Lobby is not obligated to provide health care coverage. And if they choose to do that, then if any applicable large employer fails to offer to its full-time employees and their dependents the opportunity to enroll in minimum essential coverage under an eligible employer-sponsored plan for any month, and two, at least one full-time employee of the applicable large employer has been certified to the employer under Section 1411 of the Patient Protection and Affordable Care Act as having enrolled for such a month in a qualified health plan with respect to which an applicable premium tax credit or cost-sharing reduction is allowed or paid with respect to the employee. Then there is hereby imposed on the employer an assessable payment equal to the product of the applicable payment amount and the number of individuals employed by the employer as full-time employees during such month. The product meaning as in multiplication, the applicable payment amount of that individual times the number of full-time employees. So notice that the same terminology is shared by all of these credible sources. Shared responsibility, the applicable premium tax credit, cost sharing reduction, applicable payment amount, and these are defined next. First, applicable payment amount. The term applicable payment amount means with respect to any month, 1/12 of $2,000. Applicable premium tax credit and cost sharing reduction. The term applicable premium tax credit and cost sharing reduction means A, any premium tax credit allowed under Section 36B, any cost sharing reduction under Section 1402 of the Patient Protection and Affordable Care Act, and C, any advanced payment of such credit or reduction under Section 1412 of such act. So you can go and look these up yourself and see that how these are defined and how they are determined. The National Catholic Reporter has received every year since 2000 the Catholic Press Association's Award of General Excellence. And the Catholic Press Association is stated that its purpose is to spread the word of God. So if there is any bias to this, it is a religious bias. And here we have an article titled What an Abortifacient Is and What It Isn't, titled from February 20th, 2012, starting with a quote, "One of the well-known truisms in ethics is that good moral judgments depend in part on good facts." So wrote Dr. Ron Hamill, Senior Director of Ethics for the Catholic Health Association of the United States, in the blah, blah, blah. That link doesn't work. They go on to say the HHS mandate allows women free access to all FDA-approved forms of contraception. This includes IUDs, the drug Plan B, and a new drug called Ella, which came on the market in 2010. Church officials and others have argued that because these three contraceptives are abortifacients, the government is forcing them to participate in the distribution of devices and drugs that cause abortion. The reality is that there is overwhelming scientific evidence that the IUD and Plan B work only as contraceptives. Since Ella is new to the market, it has not been studied as extensively, but as of now, there is no scientific proof that Ella acts as an abortifacient either. Ella merely delays ovulation, in fact. The Catholic News Reporter goes on to state, there is only one drug approved to induce abortion. It's called RU486, mifepristone, and is not on the FDA's list of approved contraception. It is available only by prescription, and no employer is forced to pay for it as part of an employee health plan. Just because an egg is fertilized doesn't necessarily mean it will develop into an embryo. Implantation happens 7 days after fertilization, if it happens at all. Scientists estimate that at minimum 2/3 of fertilized eggs to fail to implant, and some scientists estimate that number may be as high as 80%, according to Discover magazine. A woman is not considered pregnant until the developing embryo successfully implants the lining of the uterus. And what we know about emergency contraception is it inhibits the egg from implanting in the uterus. Next, I'm showing, and I'll provide a link below, Marty Lederman's Compendium of Posts on Hobby Lobby and related cases. And if you don't know who Marty Lederman is, look him up. Ending where I started, this is an image of the Scott Lemieux article titled "Secular Corporations Cannot Exercise Religion, My Friend." He is the author of the article I began with, and he is also the person who provided the link in one of his articles to Marty Lederman's compendium of articles on the Hobby Lobby situation. So that just illustrates how it all comes full circle when proper, unbiased, educated, and informed sources are located. There's a cohesiveness and a